Welcome, everyone. We'll probably have some more people rolling in. That's great. We are recording this training, so if you have colleagues who aren't able to make it today, we will have this available down the line. We're so grateful to all of you for joining us today on very short notice. I believe we planned this training in about a week and a half in response to significant changes that we are seeing in the treatment of unaccompanied children who are seeking asylum. So this training today is geared towards pro bono attorneys who are considering or are already representing unaccompanied children who are seeking asylum. So we can hop to the next slide. My name is Lisa Coop. I'm the Director of Legal Services at the National Immigrant Justice Center. My colleagues here with me are Jeff Sabula, Bethany Doman, Rachel Geisler, and Charlotte Saul. This team will endeavor to answer your questions in the chat and hopefully provide you with the tools that you need to work up these asylum cases and represent these particularly vulnerable children. I'm seeing a lot of very familiar names. And so I know a lot of you bring a lot of existing expertise in asylum law, which is fantastic. We're so glad that you're here. But this training is also hopefully useful to people who are newer to asylum, and we'll spend a little bit of time just walking through the elements and doing a bit of a primer on asylum before jumping into the nuts and bolts of representing children. If you have been working with NIJC over the course of the last number of years, and if you've represented an asylum seeker, probably it's been a case that's been in the defensive posture, that's gone before the immigration court. What we'll talk about today are sort of the unique features of children's cases where there is concurrent jurisdiction and their cases are actually initially heard by the United States Citizenship and Immigration Services Asylum Office in Chicago in a non-adversarial interview setting. So we'll talk about some of those differences in the way we might prepare and advocate a little bit differently in those sorts of cases. So we can go to the next slide. I've introduced us a little bit. Charlotte should have her name on there. Charlotte is our pro bono manager, and Rachel Geisler is also here, who's a supervising attorney in our Children's Protection Project, who will be answering questions in the chat. And Jeff is running the slides and is very good at anticipating when I want to move on. You all hopefully have some familiarity with NIJC. If we go to the next slide, actually, as you all know, we're a legal service provider for lower income immigrants. So there's no appointed counsel in immigration cases, and our aim is to be the lawyers for people who otherwise would be going through the system without attorneys. And that's always egregious, but it is particularly egregious in the context of immigrant children who potentially face, prosecuting attorneys from the Department of Homeland Security on their own without counsel. So the fact that you are here and considering intervening on behalf of an immigrant child is a very big and important thing, and we are extremely grateful. NIJC's model is to combine legal services, advocacy, and federal litigation. And where this work fits in is on that legal services piece. So we really try to, wherever possible, be the lawyers for immigrants in need of counsel. And then from that experience, that informs our advocacy work and our federal litigation work. So, for example, in the context of children, right now we're in this moment where the federal government is seeking to terminate legal services or their funding for legal services for unaccompanied minors for children. And so this work that we're doing today is trying to respond on the legal services prong. Meanwhile, our director of policy is doing advocacy work to try and convince lawmakers that, hey, Congress appropriated money for legal services and the government ought to use that money for its intended purpose. And we're also a part of the litigation that's taking place in the Northern District of California, seeking to reinstate the funding for this work. So that's sort of one example of how those three pieces come together. But we can go on to the next slide. We're going to give you a lot of information today. We don't expect people to memorize all of it, but we have an abundance of resources on our webpage that are available to you. In particular, our asylum manual is a really comprehensive overview of how to prepare an asylum case, particularly in the Chicago area, in the 7th Circuit. And we have all sorts of sample materials. So this is this immigrantjustice.org webpage. This is your go-to first stop for any time you're looking for a sample document or a template. It is never our intent for people to recreate the wheel. And certainly we can build upon and improve upon resources that have already been created. So keep a copy of this presentation, keep that link, and please use those resources to the extent they're useful to you. Okay, so why are we here today? I have already stolen my own thunder and talked about the changes that we're seeing in the context of unaccompanied immigrant children. So there are kind of three things happening at once. Like, first of all, with the termination of funding, there are fewer nonprofit attorneys available to advocate on behalf of immigrant children because the programs have been defunded. At the same time, we're seeing the Department of Homeland Security more aggressively move towards filing the NTAs of children and pushing their cases forward. So we're seeing these cases, which for years now have kind of moved slowly. We're seeing those pushed towards resolution. And we think this is a very intentional move by the government to seek to deport immigrant children. And we're also seeing those cases then as a part of this. We're seeing children who filed asylum applications scheduled for their interviews at the Chicago Asylum Office. And again, this is kind of a shift because until now, we would file the I-589 application for asylum, and then it would just sit at the asylum office for a very long time. And it is very possible that the backlogs at the asylum office will catch up to them again, and not all of these cases will go forward to an asylum adjudication interview in the coming year. But we think there's a pretty good chance that they're going to try to schedule a bunch of these cases for interviews. And so that's the reason why we're really looking for partners to work with us to prepare the asylum applications for children. So what that means is that you would be preparing the affidavit, gathering the evidence, putting together the country condition index, and coming up with the legal theory and articulating it in the form of a cover letter that we would send to the asylum office, or that you would send to the asylum office in the event the case is scheduled for an interview. So there's some pretty discrete components to the preparation of the case, and we'll talk about each of those. Our concept here is that you would be signing on to these cases for a period of 1 year. I think one thing that's been hard about pro bono representation of asylum seekers is it sometimes feels like firms are sort of signing a blank check, and you don't know when you take on a case whether it will resolve in 6 months or 6 years. And what we are doing here is saying we're asking you to sign on for 12 months. And we're thinking that, you know, hopefully you'll prepare that asylum application very early on in those 12 months. And we'll see if the asylum interview gets scheduled. We'll see if there are things we want to do to try and push for an interview to be scheduled, if it's a particularly strong case and we want to get it done. But at the end of those 12 months, if the case has not been scheduled for interview, that's okay. Those children will still leave this representation experience with a fully prepared asylum application ready to go forward whenever the time comes for them to proceed with their case. So it is an incredible benefit to them to have their cases prepared now. I think it's also, you know, there are other reasons why this is a really good idea. As the years tick by and memories fade and evidence becomes unavailable, there are lots of reasons why working to prepare an asylum application closer to the time when it's filed makes sense. And so we're going to try this, and we're really grateful to all of you for being willing to pilot this with us. So how is this different from other NIJC asylum work that you've done with us? Again, your time commitment is time bound. We're looking for a 1-year commitment. During that period of representation, like I said, we really want to accomplish a lot. So the idea is that we're really going to put our foot on the gas and work hard up front to get these applications prepared. I'm seeing a question in the chat. Can you keep your case longer? Yeah, you can keep your case longer if you want to. You know, we're trying to strike the balance and recognize that some firms, it's hard to keep a lot of cases on your docket for a really long time. But of course, if you have the capacity to remain in a representational agreement with your client, we would certainly not seek to disrupt that. But your task if you choose to accept it, and some of you already have, which is great, thank you, and some of you will very soon. But your task is to prepare the asylum application, and then there are other things that happen when we're preparing an asylum application, right? Your client might move, and so they need to file a change of address. We would ask for that you do that. Your child might become eligible to apply for employment authorization. We don't necessarily want kids out in the workforce, but we want them to get federally issued photo ID. We want those of them that are old enough to get a driver's license to be able to do that. There are lots of other reasons why we want children to get employment authorization. And some of these children have become young adults. Their cases have been going on for quite some time. And so they may wish to work, and we want to give them the legal capacity to do that. So we'll talk in a little bit about how that process works. And then we want to file probably a FOIA request in most of these cases. We think it's generally a pretty good idea to get whatever the government has on our asylum seeking clients. If they made a statement at the border when they had contact with Border Patrol, we want to know about that so that at the interview, if the asylum officer asks about it, we're ready to respond. Like I said, we do anticipate that the asylum office is going to move to schedule these for interviews pretty quickly. But again, we don't know. There's so much chaos in the system right now and unpredictability that we can't promise you that, oh, by June, you're going to have your application set for an interview. But we think it's quite possible that it will happen. And so again, at the end of the period, they have a fully prepared asylum case. Our expectation is not that you remain on as counsel, but again, if people choose to and want to remain involved, we certainly are supportive of that. And then we want to also address that if you've been representing adult asylum seekers, there are some different things about working with children. You know, some of them are quite young. Some of them won't remember the events that give rise to their asylum case. So we'll be leaning on their family members and on other witnesses to provide us with affidavits and evidence. Children many of them can't drive. And so we'll be figuring out the logistics of how do we get them to an appointment with their lawyer? How do we work with them to equip them to take advantage of this amazing opportunity that they have to be represented by excellent counsel like all of you. And so we'll spend a little time today talking through some of the unique features of children's cases. Okay, so let's do a little bit of a lightning round for the basics of asylum law, and then I'm going to kick it to Jeff to go a little bit more in depth. So this is our graphic of the players involved in an asylum case. And what's different about children's cases that I've already mentioned is this fact of concurrent jurisdiction. So it's very possible that children are both in removal proceedings before the Executive Office for Immigration Review. So that little picture of a courtroom, if any of you have represented adult asylum seekers, that might look quite familiar to you. But while children are in deportation proceedings, they may also be seeking asylum before United States Citizenship and Immigration Services in that non-adversarial affirmative process before the asylum office in Chicago. Most of the children that we are hoping you'll take on for representation right now have had their removal proceedings either terminated already, which is great, or their charging documents have not been filed in the immigration court. There are a few that may have court hearings. Those court hearings, while the asylum application is pending before the asylum office, is typically pretty perfunctory. Usually we can go in, and if we need to go to court, we can request a continuance because judges will understand that in the cases of unaccompanied minors, we have to let the asylum office have the first adjudication of the asylum office. So that's a distinction between, yeah, you can go on to the next slide. That's fine. That's a distinction between these cases and the cases that you may have handled before. Refugee definition is the same as applied to children. Jeff will talk about some of the ways that some of the legal interpretations might be different. When it comes to children, the standard for what is persecution, some of those other requirements might be modified to some degree when we're talking about children, but we're still working with that same refugee definition that is housed at Immigration Nationality Act, Section 101, the definitional section of the INA. So we're looking to establish that these children have a well-founded fear of persecution that the government is unwilling or unable to control on account of a protected ground, whether that's race, religion, nationality, political opinion, or membership in a particular social group. And if you've done asylum with NIJC before, you know that we spend a lot of time in that particular social group space. And the same will be true of these children's cases, where a lot of them will be seeking asylum based on their family group membership, based on their status as someone in a relationship they're unable to leave, based on the fact that they've flouted gang norms, that they've refused to do the things that maybe a gang or a cartel or some other entity is trying to force them to do. And those might be the sorts of claims that we'll commonly see among these children's claims. We can go to the next slide. All right. And of course, that definition breaks down into discrete elements. So that well-founded fear, that can you show that 10% likelihood of future persecution, of harm that rises to the level of persecution, right? So we want to make sure that we're keeping all of these elements separate as we're building the asylum case. Who is the persecutor? Is it the government? Or if it's not the government, is it an entity that we can establish the government is unwilling or unable to control? And then there's that nexus prong. So bringing those pieces together, showing that that persecution was on account of the protected ground being race, religion, nationality, political opinion, or PSG. Go to the next slide. And just so you are aware procedurally for the children, I believe every case that we're asking pro bono attorneys to become involved in has an I-589, an asylum application that has already been filed. So you will not need to complete that form for the children you are representing. You'll want to review it. And I actually think a really nice way to open a relationship with a client is to take a look at that I-589 and at minimum go through those first biographic pages at your first meeting and get to know the client a little bit, make sure everything on there is correct. You may end up needing to file amendments to the I-589 when you go to your interview, if the address has changed, if something else has changed, or if something was not captured correctly on the original draft of the I-589. So we'll make sure to provide you with this application, which is already filed on behalf of the children, and to also be aware that, as always, when we're applying for asylum, we are simultaneously applying for withholding of removal, that other form of protection that carries a slightly higher burden of proof, but is available to some people who may not qualify for asylum. We think the children that we are asking you to represent are all asylum eligible, so withholding of removal is a nice fallback form of protection that you don't have to do anything else to apply for withholding of removal. It's a part of the I-589. So that form of relief has already been requested. And then there's that little box at the top of the application where we will have indicated that the children are also seeking relief under the Convention Against Torture. And again, we view asylum as the primary form of relief that we'll be seeking, but we want to preserve the opportunity to seek withholding of removal or relief under the Convention Against Torture. For example, Jeff in a little bit is going to talk about some of the bars to asylum, including the terrorism-related and admissibility grounds. We've seen the Trump administration designate Mara Salvatrucha and other gangs and cartels as foreign terrorist organizations. And so should an adjudicator find that a child who had forced membership in one of those groups or was, under duress, forced to cooperate in some way, that child might face one of those bars to asylum, we absolutely want to make sure that we're preserving relief under the Convention Against Torture, because a finding of someone being subject to those bars generally will not prevent them from being eligible for relief under the Convention Against Torture. All right, I'm going to kick it over to Jeff. And you all can go ahead and drop questions in the chat as we go.
Thank you, Lisa. All right, so now we are going to go more in depth on all of the elements that Lisa mentioned. For those of you who have taken asylum cases in the past, this will be a little bit of a review, but I think this is still important, partly because with all the shifts in government policy and practice, it's all the more important that we be very focused and deliberate in how we lay out our arguments and how we prepare clients. And so reviewing kind of step by step how everything breaks down is, I think, more important now than ever. And also we will be highlighting along the way places where some of the arguments or ways we think about these elements might be a little bit different for some of the children asylum seekers. If you are new to this whole area of law, some of these things will be pretty straightforward. Some will be very complicated, and you may not feel like you have a grasp at the end of, let's say, 40 minutes of going through this. That is normal. That is why we have all of those resources online that Lisa had mentioned. That is why we have technical assistance available. That is why, we're making recordings. We will circulate this presentation. You can review, you can bone up on all that stuff, and it is all doable. It just sometimes takes some time to work through all of it. So, and I'll also say that Lisa mentioned withholding removal and Convention Against Torture protection. We will not be covering those because this is focused on affirmative applications, and those are under the jurisdiction of the Immigration Court. So it's all kind of wrapped up in the same application. Those are arguments that may be relevant to the clients in the future, but for what we're focusing on, asylum is going to be the entirety of our conversation. All right, so again, here are our elements. Well-founded fear. of persecution by the government or an entity the government cannot will not control on account of a protected ground. Five protected grounds: race, religion, nationality, political opinion, and the most mystifying when you meet it for the first time, membership in a particular social group. These elements are separate. Keep them separate in your briefing. Do not conflate these under any circumstances. We will say that again as we go along. All right, so well-founded fear. That means you are afraid and there's good reason for you to be afraid. And there are two ways to establish that. One is by showing what's called past persecution. That is that you have harm in the past that your client has suffered that rises to the legal standard of persecution, and all of the other asylum elements were met when that harm occurred. So it was, caused by an entity the government would not control, on account of a protected ground. And if you show all of that, harm rising to persecution, then there's a presumption that you have a well-founded fear. The other way of meeting that is to show what's called a reasonable possibility that harm will occur, rising to persecution, and meeting all the other asylum elements. The important thing to always underscore with reasonable possibility is it was never intended by the legislature to be a high standard. It has long been interpreted in light of the Cardozo-Fonseca decision as a 1 in 10 chance of persecution. So it's very clearly much lower than a probability, right? It's not a more likely than not standard. It's a much lower standard than that. And that's really important to keep in mind. So let's talk about the well-founded fear based on past persecution. That, as I said, you have to show all of the asylum elements related to that past harm, and that will create this rebuttable presumption of future persecution. And there are two ways that the government or the asylum officer in this case, and during their analysis, would find that to be rebutted. Either changed circumstances. So this is like a major change, so much that the applicant wouldn't be in danger if they returned. So like a fundamental change in country conditions would be an example of that. That this threat is now no longer present because things have changed so much in country of nationality. Or a safe, reasonable option of internal relocation. Importantly, it has to be safe and reasonable, right? So they would have to be able to live somewhere within that country where they can avoid the persecutor. And it would have to be reasonable to expect them to do that, right? So we're not talking about living in hiding. We're not talking about moving to a place where there's no opportunity to find a job or housing or any way of sustaining themselves, right? It has to be something that will be reasonable for this person to do based on who they are, their age, their education, all those factors. If we're talking about the future fear, then it's a combination of it being a subjectively genuine fear, you're actually afraid of going back, and an objectively reasonable fear. Plus there being no safe, reasonable relocation alternative. And small thing to keep in mind here, the burden of proofs on the government for relocation when you're in past persecution land, when you've established that. For future persecution, that burden is going to be on the applicant. So when you're arguing it, just keep in mind when you have the burden of proof. And here, you would have that burden. And then that will establish a well-founded fear. This is the first place where I think we have a little bit of a difference in thinking about especially the younger clients. It can be harder for children to articulate the subjectively genuine fear. I mean, in general, it can be difficult for people to articulate like exactly why they're terrified to go back to the country for a variety of reasons, including cultural and it not being something that they want to think about, trauma related. There's a lot of reasons why that can be hard to articulate, but for kids, it's especially hard, especially if they're really young. There is some guidance in the UNHCR manual, which has been adopted by the Asylum Office in trainings in the past, explaining that this is a harder thing for children to articulate, and so more general statements of fear are to be expected, and it would be unusual for an asylum officer to expect a like very thorough articulation of the reasons for returning for a little kid. And also that same guidance encourages to look at the objective factors more and weigh those more heavily than the subjective part of it. So there is, a little bit of guidance there, but it is, I think, something to be attentive to, especially when you get to that stage where you're preparing for the interview. This is for if you have a client that is scheduled. That's something you might need to work with the client on a little bit is figuring out what they can say and how they can best phrase it. And when we are in that situation where you're scheduled for an interview, you would be in contact with your NIJC point of contact at that point to talk about the practice sessions for the interview and stuff like that. And so we can also kind of help guide that and understand how to do that in a particular situation, but just flagging that as a thing that is more likely to come up here. One other thing that we want to mention that is available in all asylum cases before the asylum office, but may be more persuasive for kids' cases, is humanitarian asylum. And so when I said before that you have to establish either past persecution or well-founded fear of future persecution, and I was talking about the kind of rebuttal on the past persecution part of it, there is still an option for the asylum office to grant asylum if you've established past persecution and it has been rebutted. So if there has been a change in circumstances or if there is that safe, reasonable alternative for relocation, there's still a discretionary option to grant asylum for humanitarian reasons. And there are two possible bases for that. One is based on the severity of the persecution. So the idea is essentially the harm suffered in home country was so extensive that it would be the language used in some opinions is unconscionable, or it would just essentially be cruel, be wrong to send that person back to that country given what they've been through, right? And so that is one of the standards that they could apply to grant humanitarian asylum. The other is a reasonable possibility of other serious harm. So maybe there's not any, you can rebut the likelihood of future persecution based on a protected ground, but country conditions are really terrible, and there would be a reasonable possibility of serious harm that doesn't fit one of the protected grounds in the asylum definition. In that case, there is a discretionary option to grant asylum. This is always a fallback. This is never going to be your main argument, but it is something to be aware of and something that in many cases you may want to incorporate in your briefing. Now, we've been talking about persecution, and it's important to realize that there is a legal standard for that. And essentially, it falls into three categories. Persecution can be significant physical force against a person's body. That's sort of the most straightforward one, right? Like actual physical harm. Or it could be the infliction of comparable physical harm without the direct application of force, which is a mystifying way of saying a pretty simple idea. Like, take the example of someone being locked in a room without food and water. That is causing physical harm. It's causing hunger and thirst. But there is no physical force. There is no beating or anything like that happening. And so that's what that category is encompassing. That type of physical harm that's not by force. Or the non-physical harm of equal gravity. The kind of textbook example of this is holding a gun to someone's head, saying that you will kill them, and having them imminently fear that they will lose their life. Right? That is the kind of physical harm that could be non-physical harm that could be of equal gravity to significant physical force. Very important. Actually, and before I get to the important one, I also say harm is always cumulative. So there may be a lot of things that happened in the past, and you are always adding those up. It's not any one event has to meet that definition. All right, but here's the important thing in this context. There is ample case law and existing guidance for the agency saying that the harm to a child can be less than for an adult and still rise to persecution, right? You know, and it's really important, therefore, to the extent that you can make this clear in your affidavit and briefing that you show the age that all of the instances of harm occurred at. And I'm particularly thinking of like kids that are now older, like they were children when they were placed in proceedings, but they may be a little bit on the older side of the spectrum now, making it very clear in how you present it to the asylum office that this happened at a young age. I think is really important to keep in mind. So now we're going to go to a hypothetical, which we will return to in several occasions during today's training. And we'll read it through this time. And then we'll also put a couple of questions on the screen, which hopefully I'm launching now. And so you can look at these while we're reading through the hypothetical and submit your responses. So here is the situation. Ruben is a young man from Honduras. Growing up, he lived with his parents in a neighborhood where gang violence is common. He belonged to a church group that discouraged other young people from joining the gangs because it contradicted Jesus' teachings. One day, MS-13 began to extort Ruben's father, demanding a tax from the store he owned, and they threatened to kill his family if he didn't pay. The gang also tried to recruit Ruben's brother, who fled the country. Then one day on his way home from school, Ruben was beaten by several young men with tattoos and firearms. They told him to stop telling people not to work with them. One of the men held a gun to Ruben's head and threatened to kill him the next time he saw him. Ruben, sorry, I need to move this window. Ruben fled to the United States. Since arriving here, he has come out as gay. He has not told his family in Honduras because he's afraid of how they would react. So the questions that we'd like you to answer first are which of these events described here would be important to the past persecution analysis? That's question one. And then the second question there is what is going to be relevant to the reasonable possibility of future harm? And I'll give you just a moment to do this. Timing-wise, we unfortunately won't have very long on these answers, so just and don't worry, none of this is graded, so just drop in whatever comes to mind first, and okay, good. All right, so we're getting a lot of responses, and it looks like it across the board, people agree that the physical attack on Ruben would be important to the analysis. That's absolutely true. Um, and then a lot of people are also mentioning the threat against him, and that would also certainly fall into that. This is the non-physical harm that I mentioned before, the threat at gunpoint. That's an example. Um, the extortion to Ruben's father, a lot of people have identified, and I think we would need to know more to know if that would fall into this analysis. At this point, we don't know if it was ever communicated to him. And when we're thinking about past persecution, what we can add in that cumulative analysis, it's really important that we show that the client was harmed at that time. And at this point, we don't even know that he was aware of the time that his father was being extorted. So I don't know if we have that here, but it may be relevant. And so I think it's important to look at that one. Less clear if it would ultimately fall into that analysis. And seeing wide range of response in the second question, and that's good. I think all of these things are going to be relevant in one way or another. It's a little bit of a trick question because we don't know exactly what's going to be most relevant until we've done the full asylum analysis and have articulated our protected grounds and know sort of whether we can tie these all the things all to that. But I think all of the elements listed here may be reasons why Ruben would be at more risk of harm if returned. And so they are absolutely, I think, at this stage when we're working through this analysis, they're things that we would want to kind of categorize as potential facts that give us that objective basis, the reasonable possibility, and then as we work through the remaining elements, we can figure out what we will end up focusing on. And I know not many people mentioned him coming out in the United States, and I think we need a lot more there to know if that one fits. We would need to talk to him and also do some country conditions research to establish whether being gay in Honduras is something that would lead to persecution in the future. And that's admittedly something we haven't gone into at all yet in this training. So, but I think it is something we would want to be thinking about. Okay, let us. Oh, sorry. I need to end this poll before I can move on. One moment. Apologies. Okay, so the persecutor. The persecutor needs to be either a governmental entity or an entity that the government is unable or unwilling to control. Right? And so government entities are any level of government from the president down to the police to local mayors, maybe a village chief. Entities that the government is unable or unwilling to control could be gang members, paramilitary forces. It could be private citizens or categories of private citizens. So family members could fall into that category. And the important, sorry, I'm trying to figure out how to end this poll. Okay, and so the important thing to remember here is that it does not need to be the government itself. And when we're thinking about unable and unwilling to control, often one thing that the government will look for is whether a report was made to the police or the reasons why one wasn't made if it wasn't made. And there's clear case law both in the Seventh Circuit and from the Board of Immigration Appeals saying that there is no obligation to report persecution if would be futile or dangerous to do so. And I think that argument is often salient in cases for children who may not have any ability to report to police or would not be able to do so without the persecutor, who in many cases may be a member of the household, finding out. And that this particular scenario that is discussed in that BIA case law that I mentioned, Board of Immigration Appeals case law. And so that may be an argument that in many of these cases you will want to be attentive to. So going back to Ruben, let's look at who is the persecutor here, and I will actually give you that part. That it is certainly the gangs that we're looking at, MS-13, and maybe there's another gang involved, maybe not. Yeah, but the question is just based on the standard. What would you need to show? Would it be that the gang members actually belong to the government, that the government's helpless to control them, that a public official has endorsed it, that they are unwilling and unable to control, or that they are unwilling or unable to control? All right, looks like people are getting this one pretty much across the board. That is great. There's a trick in there that unable and unwilling is the wrong standard because it's a disjunctive. It's unable or unwilling, which is really important. But it looks like people are mostly not falling for that, which is great. Yes, the correct answer is the last one. The government is unable or unwilling to control them. Excellent. Okay. Now to the most kind of complicated elements. Nexus and the protected grounds themselves. This is often where the bulk of your legal analysis is going to rest, and these are the questions that I think are often the hardest to get your mind around at the first stage, and so at first encounter. And so the first thing that we really want to emphasize is that nexus and protected ground are separate elements. Um, that is to say that you need to establish what protected ground applies to your client of race, religion, nationality, political opinion, or particular social group. And that is one thing in itself, showing that they belong to that whatever group that is, and that group is cognizable under the immigration law. But then separately, there's an evidentiary showing that the persecution happened on account of that protected ground. And that causal analysis is extremely important. It needs to be addressed separately because a lot of cases, and we see this, as advocates, we see it in the case law frequently. Like a lot of the cases rise and fall on this nexus analysis, whether you've shown um, that evidence that the reason for the targeting, or one central reason, this is important, we'll get to that in a second, one central reason for the targeting was one of these protected grounds. Excuse me. So here's the standard. Like I said, it has to be at least one central reason for the persecution, which does not mean the reason, right? It's not the sole reason. It has to be more than a tangential reason. It has to be more than superficial. It has to be not subordinate to another reason, or at least that's one way that the BIA has discussed it, that there is an open legal question whether that's the correct way to articulate the standard. But saying it's not subordinate to another reason is at least one of the rules that gets applied sometimes. Um, but one central reason. So it has to have some central causal connection, but it doesn't have to be the overarching sole or like numerically like the most important reason. Like that's not the standard. It's just one central reason. And that means that there can be mixed motives. And if you think about commonsensically, there generally are, right? When severe harm is being caused, the persecutor usually has a number of reasons for targeting any given individual. And the presence of other reasons for doing it does not negate the fact that the protected ground may be at least one central reason. And so your task as an advocate is to find that evidence that will show that this protected ground was an important part of the persecutor's motivations. And that could be direct words of the persecutor. One thing that doesn't immediately jump to people's minds, but like is often very important is like derogatory language or slurs used by the persecutor can actually tell you a lot about their motivations a lot of the time. Like sort of the insults, the exact wording of them can be really important. It could be also based on circumstantial evidence. So if there's a particular practice that, say, a gang or cartel in an area has, they target a certain group of people with regularity, and you could provide evidence that that's what they do, that would be a strong argument. Country conditions evidence in general is often very useful in that regard because people study these things and how governments, gangs, or domestic relationships in the country operate, and when there are trends that can be indicative. Um, or yeah, or just like the overall context of the persecution. So this is a place where you want to spend a lot of time when you're working with your client on an affidavit, trying to figure out how they know, um, or I guess what they know about the person's motivations, what exactly they said, what the overall context was, and what you can use to make that argument. And now let's talk about the actual protected grounds. So we've already laid them out. Just say quickly that race is generally used broadly. It can mean Ethnic groups, it can sometimes mean like linguistic groups, although as you can see here, linguistic groups are often labeled under nationality as well. Sort of, it doesn't make that much of a difference which of these categories it falls under, but sort of like recognized national groups or ethnic groups can fall into these categories. Religion can include recognized religions or um, the lack of religion in a very religious society or differences of interpretation within one religion. So, for example, an Afghan asylum seeker could be a Sunni Muslim, but have a very, very different interpretation of what that means than the Taliban does and be persecuted on that basis. What would be kind of a classic example of difference interpretation within one religion. Political opinion can be actual or imputed, especially important to remember with children. Political opinion could be imputed by virtue of someone's family membership or something like that.
How you doing?
Um, Go ahead.
You know, love and life, perfect attendance.
Sorry. Okay. Um, and yeah. Next is membership in a particular social group, which is the often most important category and can be one of the more confusing. And so the fundamental meaning of it is a group of persons who share a common immutable characteristic. That means there's something about them, a trait that they cannot change or should not be forced to change. Um, and I think if you take that kind of kernel definition, it make I think that makes the concept a lot clearer. But what really makes it easier to apply and easier to find is by looking at some examples, right? So these are when we're talking about the traits that people should not change or cannot change. Um, these are kind of examples. So nationality has been recognized as an immutable trait. Past experience has been. Gender has been. Right, so women or girls from a particular country, Salvadoran women and girls, for example, would fit this definition of particular social group. Immediate members of a particular family, the children of a particular person, would mention that would fit this definition and is often a group that is important in children's claims because family relationships are obviously very important, especially at young ages. And so this is one we see a lot. Women in relationships that are unable to leave, women who have disobeyed gender norms. We'll look at those again in a second. Sexual orientation and gender identity are also things that you should not be forced to change. So they fall into this category. And there are a lot of kind of versions of family related claims that I can look at. We have opposition to gang claims here with a question mark because um, opposition to a gang in itself is not a particular social group, right? That is you know you wouldn't have a group of say like Honduran men and boys who are opposed to gangs. That's quite amorphous and would be very unlikely for an adjudicator to recognize that. But in these situations, you can often look into the reasons why someone opposed to the gang, or maybe the reasons why the gang is targeting them for recruitment, or other kind of factors, and find a particular social group that would apply. So someone may be targeted based on family membership, or it may be there may be like a religious or other basis for not joining the gang. Um, and and so I guess the point here is not to stop the analysis at opposition to a gang, but to kind of dig deeper, understand the motivations, and kind of look at it more closely. And some of the things that we often look at are past experiences. So two of the examples on the screen here are based in this concept that is very well established at this point, that a past experience or past act cannot be changed in the future, and it can mark someone out as a target for persecution. And so that's what's recognized in the Sarhan holding you have here. Women in Jordan have allegedly flouted oppressive moral norms. This idea that a society might have very strict kind of social strictures, social conventions, and that having defied them once could mark someone as um, a target for persecution in the future. Um, and this can apply in a lot of cultural contexts. It's a place where the country conditions information is really vital to making that argument and showing that that kind of strict moral code exists. But I think it's an important thing to look for and really think creatively about how that might fit into the country that you're analyzing. A similar example based on past employment is former truckers who resisted FARC and collaborated with authorities, which was in the I guess, Escobar decision. Different types of former employee groups have been seen. For children, it might be former membership in a group that they belonged to or something like that rather than employment, but it's important to be attentive to. And then another important one that we see a lot is women in marriages or domestic relationships that they aren't able to leave. So again, this is based on the cultural context. It's based on understanding the constraints in the ability to leave certain types of relationships within a given country. And that's just another important one, and another way of highlighting the importance of really looking at the client's circumstances and what you can find in your research about the country of citizenship. So let's think about these protected grounds with Ruben again. And I'm going to give you a little bit more time to respond to this one because, it takes a little bit more thinking. But we are going to think about what protected grounds apply, and then have let's have the five protected grounds and see which you think you might be able to make an argument for here. Then, assuming particular social group might be one of the grounds you pick, um, what are some that you may want to yes, some groups that he might belong to, and then thinking about nexus, any information that you think would be important for establishing nexus to any of the particular grounds that you picked. So just a kind of chance to think about how you would be arguing this case and what evidence you would be looking for if Ruben were your client. So we'll take a couple minutes on that, and yeah, maybe like 2 minutes to respond to this one, and then we'll move on. Um, and there aren't really strict right and wrong answers here. Just kind of think about. It seemed Nadia's asking how to get to the question screen. It was supposed to automatically launch for everyone, and I see it launch for some people. I don't know why it didn't launch for everyone. If you did not get the question screen, I apologize for that. I do not know how to fix it. But I can see a number of people are answering, so it seems like it launched for most people. Yeah, apologies for any technical difficulties. We're- yeah. And I see the great question in the chat about sort of sexual orientation and identity question claims under the current environment. And I want to repeat Lisa's response that there is some strong law on the topic that I think makes it hard to ignore, but I think that there is, particularly at the asylum office, concern about, in addition to new case law, kind of directives from um, above to focus less on these types of claims. And I think ultimately we do kind of need to lean into the fact that it's clear under the statute that these claims are cognizable and should be recognized. But we may also need to give the officer a few different ways of getting to that conclusion, in case there is some resistance against granting on a straight, like say, gay Honduran men claim. We might just need to offer some alternative phrasings to make sure that they have ground that they're comfortable granting on. But yeah, it's unfortunate to even be thinking about that. But I do think that is a very good thing to raise. So I appreciate whoever mentioned that. Okay, I'm going to end the poll because that's the only way I can see responses. Apologies if you're still working. Oops. Um, and yeah, um, great work on this. It looks like I think everyone's agreed that particular social group and religion apply in this instance. Um, have some votes for nationality and political opinion, and I think there might be some interesting arguments on political opinion in particular, and I'd be interested in hearing that. I think it's a little bit harder to get to, but it might be it really might be arguable here. So I think that's great. And I'm seeing in the particular social group responses a number of family-based claims, which absolutely agree with. And one's related to the church group and organizing, which I think is also very much correct. The LGBT claim is also very much there. And so these are all excellent responses. And yeah, and a lot of good questions on Nexus. Yeah, having to do with getting other country conditions, trying to learn what the gang may have been aware of, whether other similarly situated people were targeted, and things of that nature. So really great responses. I appreciate everyone's attention and working through this. All right, last thing we have on the legal basis before turning it over to Bethany to talk a little bit about the actual work you've been doing with the client is there are a number of mandatory bars to asylum, as Lisa mentioned before. Um, and some are related to criminal acts and convictions. Some, one important one is that there's a 1 year filing deadline, although there is sort of an exception built in for unaccompanied children and some other possible exceptions to that one. But the one that we want to focus on right now is the terrorism-related inadmissibility grounds, because, as this mentioned, there was the recent move by the Secretary of State to designate a lot of groups as what are called tier one terrorist groups, and most prominently MS-13, which is obviously a group with a large presence in a lot of countries, and also a number of cartels, including Sinaloa is probably the most famous, but yeah, there's a whole list, and then Tren de Aragua was also on there. And the reason these grounds are important is they do not apply only to sort of active members of these groups, right? it isn't like limited to people who are actually performing criminal acts to promote the ends of MS-13 or whoever else. It will include sort of anyone who's ever been forced to make an extortion payment, anyone who has been forced to do work for a gang, right? To provide any kind of service for them. The statute is written incredibly widely to sweep in a lot of conduct. And so if your client has had any interaction with one of these groups, or really any like large criminal organization, that is a place where you want to be very attentive and very careful in learning the facts um, and just be attentive that this bar may be in play depending on the conduct. There are some exemptions available, and so like for example, duress. If you say that I will kill you or your family if you do not do this very small thing for the gang, that doesn't get you around the bar applying in the first place, but it does, if it's an imminent threat of death or serious harm, get you to a place where USCIS can make a discretionary exemption and still grant the application. And so if there is some kind of interaction, and particularly if someone was ever forced to do something on the gang's behalf, you really want to understand the circumstances and be able to make that argument for the duress exemption. And I think it's going to be a very delicate kind of case by case thing, thinking about how to frame it in the affidavit and how to argue it in the assignment review. And so this is a place where I think you would have some conversations with your NIJC point of contact to kind of work out how to do this. But I just want to flag it generally as a concern to be aware of. Also, these grounds apply to activities by the applicant's parents going back 5 years in the past. So that's another thing to be aware of, right? If the parents have been extorted or have had interactions with the gang, that may also bring you into these terrorism-related grounds territory, and we'll have to go through that analysis in that case. Big topic. We can't get into it now, but I just want to make sure everyone is aware of it before we move off the legal analysis. And so my last thing before turning it over is, as you're aware, this is registered for CLE in Indiana and Illinois. There will be a survey at the end. We will give you a QR code so you can fill out that survey, and you will need to put in a code word to establish that you were here and paying attention the entire time. Your code word is protection. Protection. These are, this is our clients are seeking protection from the U.S. government. The U.S. government should provide protection in these situations. So protection is the code word when you fill out the survey. And with that, I will turn it over to Bethany.
Hi, everybody. So we're going to just talk about what you want to do when you first start working on these cases. You can go to the next slide, Jeff. Thank you. Okay, so Lisa touched on this in the beginning, but one of the first things that you want to do is file a FOIA request, a USCIS FOIA request. There are different types of FOIA requests, but you want to specifically request the one from USCIS. You can mark that as track 3 processing. That's the expedited version of a request, so you can hopefully get it a little bit sooner. You're also going to want to review the court file and the record of hearings. So yeah, Freedom of Information Act. Thank you, Lisa. And we're going to be sending the files over to you. So that will include everything that's been filed with the court or with USCIS, any filings that have been filed with the court. So okay. The purpose of, oh, sorry, Jeff, could you go back? You also want to request the ORR file. That is going to include interviews that the child did when they entered the country. And it's really important to have the ORR file for just ensuring consistencies between your affidavit and what the government already has on file. Okay, thanks, Jeff. Okay, so work authorization is really, really important to our clients. Like we touched on before, not all of our clients are necessarily old enough to work, but a lot of the kids that we're referring out are old enough to work, or they're getting close to it. And these EADs last for years. So a lot of our kids already have EADs, but these newer cases that we're referring out, they were filed in the last few months. So I would say a majority of them don't have EADs yet. You have to wait 150 days after you've applied for asylum to be eligible for work authorization. So at the 150-day mark, you can apply for an EAD. The government can't grant that application until 180 days. So there's about a 30-day window where you can file, but the government isn't going to make a decision on that application. The initial application for an EAD, I'm sorry, that's employment authorization document. The initial application is free. You don't have to pay anything. However, once they have to renew that work authorization, they will have to pay a fee. Also worth noting, if it's lost or stolen, that you'll have to reapply. Sometimes these things get lost in the mail. So if anything weird like that comes up, you can always just reach out to us. There will be someone assigned to each case that we refer out that you can have as like a point of contact to ask questions to. But yeah, if you lose your EAD, that's considered a replacement, and that means the client or the firm is responsible for paying that fee. There are fee waiver applications, but it just depends on the client. Sometimes they just want to get their work authorization as soon as possible. Additionally, when you are filling out these EAD applications, you're going to want to go right to the USCIS website and make sure you're downloading the most recent form version. USCIS changes the forms all the time, and if you send an outdated form, the filing will get rejected. Yes, we do request EADs even for an 11-year-old, for a 2-year-old. Part of the reason for that is when you request an EAD, there's a box on the application to request a social security number. So that's another advantage to requesting the EAD for younger kids, is they do get issued a social. You can file these online. You can file them in the mail. Online is of course faster. It can be a little bit of a pain because to file online, you have to create a USCIS account for the child as well. There's no right or wrong way to do it. And then additionally, if you want to check in on, like, say you file an EAD request, that form is called an I-765. Once you send it into the government or file it online, it will produce a receipt number for you, and you can go to the second link, the USCIS case status online, type in the receipt notice. It will tell you where the government is at in making the determination about an EAD. Your client will also have an I-589 receipt from when they filed their asylum application, and you can also use that link to check the status of their application. So most of, if not all of the clients that we're referring out are, if you type in the receipt status right now, it's going to say pending interview, because none of these cases have been scheduled for an asylum interview as of today. Okay, that's it, I think, Jeff. And actually, so that you don't have to go back, Jeff, but that other link that was mentioned there, it's like case processing times. That's just if your client wants to know how long is my EAD going to take to process. You can go on there. It will tell you how long each type of application is taking on average for USCIS to process. Okay. So asylum seekers' experiences are human experiences. I worked in the private practice before I did nonprofit, and I know it's very go, go, go and high volume and let's get this done. But working with children requires a different approach. You do have to be more patient. At the NIJC, we have a lot of trainings for our staff about trauma-informed lawyering. Obviously we want to get results for people, but these are children, and it's really, really important to be cognizant of re-traumatization. You have a really big role in this child's life, and limiting the impact that you have on the child is something that should not be sidestepped. And we'll talk a little bit more about different practices you can implement to make sure that you're not re-traumatizing the child any more than is, reasonably necessary to draft an affidavit. Lisa mentioned this earlier, but memories can be faulty. If a child is saying something inconsistent with something in their ORR file, or maybe inconsistent with their asylum application, that does not necessarily mean that they're not a credible witness. It just means that, trauma impacts everybody's memories, and that's especially true with children. So just know going in that building rapport with a child, it's going to require patience and time. I know before I started the nonprofit, I would get affidavits done with people in like maybe 2 or 3 meetings, and we would just have like 3 or 4 hour sessions. But I think it depends on the child, but these affidavit meetings are going to take many, many meetings, and you want to do them in shorter windows, and you want to check in with the child. Just pay attention to their body language. If they seem distressed, ask them if they need a break, ask if they want to take a walk. If sometimes it can help doing like breathing exercises with kids, asking them their favorite artist and watching a music video with them. Truly, those little things can make a difference. It will help the child feel like they can trust you, and it will help them open up to you. So it can seem like you're wasting time a little bit, but you're really not, because the more quickly you build rapport with the child, the quicker you're going to be able to get the affidavit done. And then, yeah. So another thing to consider is that some of these children have housing needs. Their parents are looking for jobs. They have financial needs that they're battling with at home. So just considering that they have other things going on outside of their immigration case. A lot of these kids don't even truly understand the significance of their immigration proceedings. So just having empathy for what they're going through outside of their case is important. And just recognizing that the family dynamics might be complicated. Some of the clients you work with might not want their parents to know everything that you're telling them. And vice versa. Sometimes you're going to work with a child who is, 7 years old, and they don't know everything. And so you're going to have to be working with the parent to be getting this information. So every case is very different. Thanks, Jeff. Okay, so at the first client meeting, the number one thing you want to do is start building rapport. Start off the meeting with small talk, start off the meeting with the parent or guardian there. That can really help the child feel comfortable at the beginning. You want to explain what your role is, what the paralegal's role is, if you have a legal assistant on the case. You want to make sure that the child understands that everything they tell you is confidential, just like you would with any adult client, but just make sure that you're explaining confidentiality in a child-friendly way. Most kids don't know what that means. And after that, if the child is, give or take like 10 years old, then you'd want to ask the family to step out. You want to start to get to know your client with their parent not there, because to do this affidavit work, you need to be meeting one-on-one with the client. And so they need to get used to you and them being one-on-one. Another thing that you might want to do before the parent leaves the room is make a plan for communication, transportation to meetings, how they want to do meetings. Sometimes if a client lives further away, if they have the technology available, you can do some of these meetings on video. Obviously, face-to-face is the best practice, but sometimes the client lives 2 hours away and that's just not possible. You also want to make sure you have an interpreter scheduled. Especially if a client is coming into the office, have that pre-scheduled. A lot of our clients do speak Spanish, but some of them do speak more rare languages like indigenous languages. And it's not always easy to get an interpreter at the snap of your fingers. Additionally, when you do start meeting with the client with the interpreter, you want to make sure that your client is okay with the interpreter and can understand them. And that's another part of giving the client autonomy to feel like they're in the driver's seat. If they don't like the interpreter or they can't understand them, it's giving the child some agency into having an interpreter that they do like and understand. And I know at our organization, we'll try to, for those languages where it's not just Spanish, if the child really likes an interpreter, we'll write down that interpreter's number, like their badge number, so that we can request them in the future. And that allows for the child to have some consistency as well. So also at that first client meeting, you're going to want to talk about a roadmap. So meaning telling the child, you know, we want to get an affidavit, meaning a statement done with you in the next 8 weeks. What I think that means is that we should meet every week for 1 hour or every other week for 2 hours, whatever that looks like. Just get some type of plan established at that first meeting. You can also go over the engagement letter in simple terms with the client, depending on how old they are. And then you're also going to want to have them sign all of the forms. So that would be the FOIA request form, just allowing the government to release that information to you. You'll want to have them sign the signature page on the I-765, which is the EAD application. And you can start to work on the claim a little bit, like perhaps talking to the child about their life in home country, but we typically avoid talking about the more traumatic parts of the client's claim at the first meeting, because again, the purpose of the first meeting is to just build rapport and establish trust. Okay, and I touched on this a little bit, but just to go over it a little bit more in detail, the interpreter is only there to interpret. You should still be looking right at the client. It's really easy to look at the phone where the interpreter is, but that eye contact with the client is really important. Set guidelines and expectations with the interpreter as well. So if this is going to be a 2-hour meeting, the interpreter should be told that at the onset of the meeting. Also try to ask short questions, avoid asking leading questions, and avoid compound questions as well. Just short, open-ended questions are the best way to elicit, details from your client. And as I mentioned before, limit the duration of these meetings for the interpreter, but also for the child. These meetings can be really heavy for everybody, and I think everybody starts to kind of check out at a certain point. So just pay attention to how your client is doing, and pay attention to the interpreter. You can tell when the interpreter starts to check out. And then, as I mentioned before, just make sure the child understands the interpreter. Sometimes there are different dialects, and you call thinking you're getting an interpreter that your client will understand, and they cannot understand each other. So it's really imperative you don't skip that step. And I think I'm passing it over to Lisa.
Yeah, back to me. Hey, everyone. Jeff, we can go to the next slide, which is a graphic of how we recommend you conceptualize these cases as you are preparing them. I think it's really easy to get super focused on step 1 is to write the affidavit. Step 2 is to gather the evidence. Step 3 is to write the legal argument. And those things make sense, but you don't want to do them independently. You want to be thinking about those things in concert. So as you're interviewing the child and drafting the affidavit and learning the story, like sort of on background in your mind is like, what is the corroborating evidence that might support this factual assertion that the child has just shared? So if the child says, and then my brother went to me with the store where the gang confronted us, you're thinking, oh, is the brother someone from whom we might be able to get a supporting affidavit? Or is there, some other piece of evidence that we want to keep in mind? And then you're also, I would say, after every meeting, stepping back and thinking what particular social groups or other protected grounds are emerging, so that you are intentionally seeking facts so that your affidavit builds the case and establishes membership in that particular social group. So the point of the affidavit, and Jeff, you can go to the next slide because we'll talk a moment about that. You know, the point of the affidavit isn't to tell a full, you know, biography of the child's life. It's to really identify the salient facts that build the asylum case. So really trying to hone in on what are the important points to include, and direct your questions in that way is really critical. So the affidavit, like we always talk about, this is the centerpiece of the asylum case. This is your client's testimony. This is the thing the asylum officer is going to have open before them while your client is testifying. And so you want to make sure that there's credibility, that the affidavit and the testimony are aligned, and what's on that page does not differ significantly from what the client is going to say, because credibility is such a significant factor in asylum adjudication, and adjudicators are given all kinds of latitude to make negative credibility determinations, and those are some of the hardest things to overcome and appeal. And again, just so you're aware, if we didn't say it clearly enough at the outset, and I may not have said it at all, after the initial interview at the asylum office, if the child doesn't prevail, the case does get transferred over to the immigration court, and there's a second bite at the apple, and there's de novo review, and there's another opportunity to win the case, which is terrific. We want to make sure that we're building the case. You know, we definitely want to give it our best effort at the asylum office and hopefully prevail there. And if not, you know, have the case move on with a really strong underlying record. So keeping credibility in mind and building those layers of credibility through the affidavit, through the testimony, through your corroborating evidence, through your country conditions support. Those are all really critical things. We can go to the next slide. As you were writing this affidavit, and again, you know, as Bethany said, you want to kind of ease into your relationship with a child client. You don't want to, like, you know, hit them with, tell me the worst thing that ever happened to you at your first interview. That said, we're trying to move really fast on these cases, and so we don't have the luxury of spending months building rapport and you know, working up to getting into some of this more difficult stuff. So I think, you know, read your client, consider the age of your client. If your client is 17, 18, if they're a young adult and they're maybe more able to engage more quickly, that's great. You should push forward. And again, like, we defer to you all to read the situation and read your clients and determine what's going to work with them in terms of how quickly you can put together the affidavit. You know, I like to think of, you know, there are times in, you know, law school clinics last for a semester. In the course of, like, you know, 2-3 months, they're putting a whole case together. When we're working with immigrants who are detained, we're often going at a much faster speed. I would see the approach to these cases being more akin to those contexts than maybe the adult non-detained asylum situation, where you sometimes have months or even years to work up a case. We do want to be pushing to go quickly in these cases. So I think having a standing meeting, I think figuring that out at the very outset of the hearing is really good and important. You know, I recommend when you meet with a child for the first time, you know, saying, our Monday afternoon's a good time. Okay, that's great. Let's plan on meeting every Monday afternoon for the next 4 weeks to do this affidavit, or the next, you know, 6 weeks, whatever it is you end up needing. And of course you can deviate from that if you need to, but I think there's a lot of value both for yourselves in you know, having the consistency and knowing, having it built into your schedule, and for the clients to have that reliable, predictable time, and for them to understand the expectation that they need to show up at this appointment every week in order for this to work. I think, you know, survivors of trauma, it's hard to talk about these things. It's hard to engage on these things. It's painful. We often see clients who start to sort of avoid our meeting with their attorneys because it's not fun to go through this process. But I think that's the importance of, like, establishing sort of the expectations and making these appointments as child-friendly and humane as possible. Recognize that these are children in a system where they're being treated like adults. And so there are some things that are just inherently really challenging about this. But yeah, I mean, letting the kids, you know, make choices where they can. I think sometimes it's really useful to say, like, hey, at some point we're going to have to talk about this really hard thing that happened to you, but it doesn't have to be today. So would you rather talk about your encounter with the gang today, or would you prefer to wait and do it next week? And then you're making very clear that you have to talk about that and explain why you have to talk about that. My answer to that question is always, because we need the adjudicator to understand why you need protection. It's never about, like, because I want this information from you, or because I, you know, want to ask you all these difficult questions, it's because I understand that you need protection and I want to help you get that protection. And the way that we do that is by making the asylum officer understand your story. And the only way we can do that is by making sure we have a strong affidavit. So we can go to the next slide. You know, some of the tips to keep in mind, sometimes children will have a lot of other people in their lives who want to advocate for them. It might be like a friend from church, or it could even be a parent or an aunt or an uncle or a sibling or something. And they may say that they feel more comfortable with that person in the interview. I always ask extraneous people to leave because one, it potentially compromises confidentiality, and also because it is extremely common for children to be unwilling to share for any client, to be able to share things the way you need them to share things when someone else is in the room. And so, like Bethany said, you can start out with their sort of support people there, but then ask them to excuse themselves so that you can establish rapport and trust in your relationship with your client. Be aware that some of these children have had very limited opportunities to attend school and so may not be able to read or write. So we generally caution against asking them to, like, hey, why don't you go home and your homework for the week is to write up your whole declaration and come back next week with, you know, your version of your story. I think that's generally not going to be the best method in these cases. I think it works much better if you are interviewing the child, you are drafting the affidavit, you are of course reading it back to them multiple times to make sure everything is correct and included. But recognizing they're going to have limited capacity to do much of this work themselves. Again, just echoing what Bethany said, you know, have snacks, take breaks, you know, try to, you know, alleviate the tension and the difficulty before a child leaves your office. Spend a little bit of time just sort of like backing out of the difficult stuff. So talk to them about sports. What's their favorite soccer team? What's their favorite novella? What's their favorite, you know, have, and you can do, like, I'll sometimes just like Google these things on my own so that I have like little tidbits of conversation to have with kids. What is their favorite food from their country of origin? Have you ever tried that food? Some of those small talk things feel really minor, but can be very significant in building your relationship with your client. We can go to the next one. When you are writing the affidavit, again, this is the child's voice. And I think we're lawyers and it's really tempting for us to use lawyerly tones and languages and styles in these affidavits, but the place where you get to do that is in your cover letter. When you're doing the affidavit, it really needs to be the child's voice. So we're not dropping in like citations to anything or references to country condition documents. We're not saying like, I belong to the particular social group of, you know, Honduran children in relationships they're unable to leave. Like, again, that save that for your cover letter where you're making the legal argument. Tell the story in the child's voice in the affidavit. We can go ahead to the next slide, which I think has some of the, yeah, you can just open up all of those, Jeff. You know, some examples of things that you don't want to do in an affidavit. Again, avoiding legalese. The second one is one that we lifted from a case that we picked up where someone had written an affidavit on behalf of a child client that included words like melee and ostensibly and cursory and superficial, terms that no child, regardless of whether they've gone to school or not, is likely to use. So that just, it just screams that this is the attorney writing an affidavit versus the child. And we're in this time, you know, Dave mentioned in the chat that, you know, there are all these additional scrutinies happening in these cases, and one of them is looking at, like, did the child really prepare this application? You know, what is the background here? And so making sure that we're you know, being very clear that this is the child telling their story in their voice. That doesn't mean you don't use proper grammar or, you know, you want it to make sense and all of that, but you do want it to not be your lawyer voice. Dates and numbers, I almost always keep out of the declaration, even if a child is, or any client is extremely confident that this event happened on May 10th, 2018. When they are under the pressure and all that adrenaline is coursing, you know, during the asylum interview, those dates, those specific numbers get jumbled. And so we're always saying, you know, in about spring of 2018, such and such happened. And I was approached by a number of gang members, not 6 gang members or 4 gang members, because we're not stopping and taking a head count in a moment of crisis. So making sure that you're leaving space for your client to have room for some of that information to change. Sorry, Jeff, you can go to the next one. All right. Corroboration. Wait, does this come back to you now, Jeff?
Yes, yeah, I can. All right, so corroboration. This is the second most important part. Looking at, thinking of the triangle that Lisa shared before. You're thinking about it all the time as you're going along, working the affidavit, as your client is explaining things. You're thinking through, what corroboration could we reasonably obtain for these facts. It is required unless the applicant does not have the evidence and cannot reasonably obtain the evidence. Which is to say, I guess coming from the opposite angle, that the testimony can be enough in itself. And if that testimony is credible in the interview and the affidavit, that could be sufficient. But where evidence would be reasonably obtainable, the government has the right to require that evidence. And so you want to be thinking about that as you're working on the affidavit, finding those pieces of evidence, and where they are not reasonably obtainable, you want to be able to explain why. And if it's something that would sort of be an obvious thing to include, let's say most of the persecution was communicated, or most of the threats were communicated through like one family member, and we can't get an affidavit from that family member. That's the case where you would probably want to build into the affidavit explanation for like, and I haven't talked to this person in however many years. I don't even know how to get in touch with them, or they were killed on this date, or something like that, right? Like, whatever the reason is why you wouldn't be able to obtain that evidence, something you can kind of preemptively address in the affidavit, but also want to be prepared to address in the interview. And so this is for every element of the asylum claim. Again, think of it as a triangle. You're also thinking about your legal argument. And so, thinking about each element, can you corroborate it? How? And if not, why not? So I mean, it's relatively simple and straightforward, but you have to be thinking about it continually as you're working through it. That's the important thing. And so lots of different types of evidence are out there, and it's going to depend on the case what is going to be the most valuable, most obtainable. There's country conditions evidence, so there's lots of different reports that you can pull from. We mentioned the State Department Human Rights reports, often a crucial piece of evidence. I will flag that it was announced that they are going to start omitting certain sections going forward. So the existing reports as of today should still be relatively strong and useful, but their reliability may decrease. Just putting that out there. But other lots of other resources out there that should be creative and research, and any credible, well-documented source can be helpful for these claims. A lot of things are going to be client specific, and I think this is something that I mentioned on one of the upcoming slides, but want to flag here that this is a place to make your client a partner. Work with the client to figure out who they think would be helpful to submit a supplemental affidavit, what evidence they may have or think they would be able to get their hands on easily. And depending on the client's age, this is something, again, as Lisa and Bethany were saying, like the parent's not going to be in the room for most of the client meeting, but when you do have a meeting with both of them, the parents can also help identify these sources. For establishing past persecution, often if there has been any medical treatment or any contemporaneous pictures that could help establish a physical injury, depending on the nature of the physical injury, a forensic medical examination may be a way to establish it. Mental health evaluations can be as well, depending on the case. And then thinking about future persecution, listing a few things there, but often like targeting of similarly situated individuals, or those incidents that didn't raise harm in the past but show that the persecutor is targeting this person and would be likely to continue to do so, can be helpful from that perspective. And of course, country conditions again. And so let's look at Ruben one more time, and can take a moment to reorient yourself to the story while I pull up the poll. But essentially, the question is going to be, what corroborating evidence would you think would be obtainable in this case? Sorry, I'm having trouble launching the thing. And assuming that one of the types of evidence may be uh, declarations or affidavits from family members, or other individuals, who might be a good candidate to present an affidavit, or like who might you want to ask Ruin about whether they would be able to provide an affidavit. So, okay, just launch that. So who would be a good candidate for supporting affidavit? What other corroboration would you want? We'll give 1 minute to respond to this. And I'll try to give some heads up before closing the poll this time, because I realize I did not do that before, and it's helpful to know when we're about to close it. We have 20 seconds left. Seven seconds. So finish up anything you are typing, and we will close the poll now. Okay. So that's really just an opportunity to kind of think creatively about what may be available, and so I'm trying to pull this up to see what people have been saying. Screen is okay. So here we go. Yeah, so people mentioned the brother, the father, may be good. And yeah, and so I think for both of them, you would want to either try to get an affidavit or confirm where they couldn't do that. Someone also mentioned a church official might be a good idea, and I think that is a good thing to look into, or someone involved with the church group. Great suggestions all around. And yeah, any records of the injuries, photographs, things like that are all good things to get. So thank you all for your work on that. And let me continue with just a couple more points on corroboration. So again, like I was saying before, work with your client. They are the person who is closest to all of this, and they know what is available. And and also family members may be able to help with that. You want to establish chain of custody. And this is not a situation where we have like rigorous evidentiary standards that we need to meet for submitting to the asylum office, but we do want to feel confident in any evidence that we are submitting, obviously, right? Like we want to feel confident that it is accurate, and that we know its provenance, and we would feel comfortable ourselves and our client standing behind it. So we want to know how they obtained the document. If some official documents will have more evidence of origin than others, like stamps and things like that. If it was mailed, just retaining or viewing the envelope that it was mailed in could help verify that. You don't necessarily need to submit that to the asylum office, but just kind of as a way of confirming that you know where the thing came from. If there are any doubts about authenticity, you would leave the document out, which I think probably goes without saying, but might as well say that. Yeah, but again, there aren't any strict rules of evidence. There isn't like a particular like documentary trail or something like that you need to submit. Often, like if the only thing obtainable um, is not the original document, but like a photo or copy, but you can feel reasonably track down enough information that you're feel secure that it is an authentic copy. That is fine. You don't that will generally be accepted by the asylum office. While the case is pending, moving a little bit off preparation, but just kind of general things to think of when it's pending. You want to monitor the case. So from the moment that you've accepted representation, started working with someone, one of the things in the case file, receipt notice, and it will have a receipt number. If it's a case pending with the Chicago Asylum Office, that is a number starting in ZCH, followed by a bunch of digits. And that number can be plugged into that website that's here. We'll circulate that. You can also just Google USCIS case status, and you'll get that link. And you go to that site, input the receipt number, and it will tell you the status of the application. Generally, if the application has been submitted and no interview is imminent, it will just say next step is interview. But at some point, for everyone, that should change to interview has been scheduled. And I would recommend checking this fairly frequently, maybe even weekly, because they do not send the interview notice with a whole lot of lead time, and it takes a while to get to you in the mail. And so you will likely be able to verify through this website that an interview has been scheduled before the notice reaches your office. And at that point in time, you can contact the asylum office by email and try to verify the interview date. And that will give you a little bit more time than if you're just waiting for the notice to come. Or I guess, sorry, the notice will come to us. I apologize. Scratch the thing about the notice coming to you. Forget I said that. But I would still check the status because you may be able to learn something about an update in the case before the notice reaches us and we inform you of the interview. If they would benefit from therapy, we can help recommend some places to refer them. But I think connecting with that is often beneficial to people. If you think a forensic evaluation would be appropriate, it's never too early to get working on that. Very important thing is just maintaining contact to develop that rapport, to develop that relationship. Especially building the trust with these young clients. That is the crucial central thing. As Bethany mentioned before, if they are eligible for work authorization during this year, want to make sure that get that filed, whether initial or renewal. This is something that we communicate to all the clients. They should not be submitting any applications for immigration benefits without discussing it with their attorneys first. And so also making you aware that that is the explanation, that's the expectation that they should check in with you before that. And yeah, and then if anything major changes in your client's life, let's say they are arrested, God forbid, or they get married or have a child or something like that, please inform us so that we can consult, or if they are a victim of a crime, kind of the converse to the rest. That is something that we want to be aware of in case it has some effect on this case or opens up another avenue to relief. And so they should be communicating with you. You should communicate with us and can evaluate that. Okay. Now we're going to talk about representation at the asylum interview. And this is both sort of what actually happens at the asylum interview and preparing for that, and talking about the documents that you would be submitting. As we've been saying before, you are working on your arguments and collecting evidence in the affidavits from the beginning, but you would only be submitting that to the asylum office once an interview has been scheduled. And so let's say we're at that stage where it's scheduled, then this is kind of what we're looking at. Um, so just to give you a sense of what the interview is, it is generally informal, it takes place in an office setting. So like just a small office room, you're sitting on one side of the desk, or your client's on one side of the desk, you're sitting behind them. And it should be non-adversarial. The officer should just be kind of asking questions to try to draw out the claim and understand what's going on, that they should not really be interrogating. But they can ask hard questions and challenge credibility, right? So it's not necessarily just a completely friendly, informal atmosphere, but it should be something significantly less adversarial than, say, a cross-examination. And so the officer will ask questions about the application, the claim for asylum. All of this information is confidential. Some clients have fears about things being leaked to family or to home country, and so it's helpful to reiterate confidentiality, both yours as the attorney and the confidentiality maintained by the government at all. As to sorry, I mean to frequently reiterate that is often helpful. The attorney's role is usually quite limited in these interviews. They want to hear from the applicant, and you're mainly there to maybe clarify a couple of things, maybe give a brief statement, but you will not be involved in the questioning directly for the most part. And all of the materials should be, so that's your brief, your corroborating evidence, the client's affidavit, all that should be filed 1 week before the interview. And specifically, what we are looking at filing is a legal memo, or is essentially a short brief that is in the shape of a cover letter. The client's affidavit / declaration, notice of any amendments to the I-589 application. So if something has changed on that form since it was filed, which happens, like address changes or something like that, we would want to amend that. If you're making any significant amendments, like something that would affect the basis of the asylum claim, that is definitely a conversation you would want to have with your point of contact at NIJC. But generally but generally, like, updates would be part of this filing. An annotated index, which will show an example of in a second, and then all of the supporting documentation, identity documents, if there's an expert that you're bringing in, their affidavit, any other corroboration. So here's kind of what the annotated index looks like, more or less. So you can see that it's done by tab numbers. For a big paginated filing, usually have the affidavit at front. Any amendments would also be toward the front. And then any personal documents you have that pertain directly to client would come next, and then all of the country conditions evidence. We can provide more extensive samples. This is just to show you the format. We can provide a sample that actually shows you what the bulk of it looks like. As you can see, when we do country conditions, we don't just identify the document that has all these great relevant things. We also have pull quotes to draw the officer's attention to the most relevant things in there. And that is important because it would be a mistake to assume that the officer definitely has time to read this giant stack of papers carefully. They need some help orienting on what the most significant facts are, and this is this way you can do that. If there is any audio or video or I don't know, something like that, you can do transcripts for that. They may ask to see or listen to the original at the interview, but you can submit it in sort of a written form for this purpose. For like, say, WhatsApp messages or other digital things like that, you can use screenshots. Anything that is not in English, you will need a certified translation for. And that's signed by someone saying that they're competent to do the translation, that there aren't specific, I guess, like criteria for like being a licensed translator or something like that. And for country conditions, we want recent examples. Plus, if it's been a while since persecution happened, some documents from that time are also relevant. But in term, so, you know, it might be a combination of like things from 23, 24, and whenever the persecution happened. But sort of the emphasis, especially for the future fear claim, should be really recent examples because that's what's going to carry the most weight. This So again, in addition to having the pull quotes, it's also best practice to highlight those parts in the country conditions documents. We have some stuff about tool punch and alphabetic tabs, but to be honest, the asylum office seems to prefer digital filings for the most part currently. So you will, in practice, likely be filing by email to that address. There is a file size limit, so you might have to break it into a few smaller chunks. I don't remember the upper limit off the top of my head, but just be aware that there is a minimum file size. We can confirm that with you as it comes up. But in reality, you will be filing by email 5 days before. Very quickly, just to address the legal memo, we want to keep it brief, and we want it to be as like reader friendly as possible. So lots of headings, very sharp descriptive language. It's normally somewhere between 10 and 15 pages, single spaced, I would say is a typical length. Yeah, we want to make it as clear and concise as possible. Again, we do not conflate elements. We keep them separate all the way through. And again, I'll harp on nexus and protected grounds need to be kept separate as points of analysis. The asylum office is a bit less concerned with case law than, say, the court would be. And so I don't think you wouldn't need extensive legal citations. I think some circular case law will be persuasive, but I wouldn't spend a lot of your limited time and energy on this, specific case citations. One thing that is often helpful to look at is there are RAIO trainings that are available online that have been used in the past for like how the asylum officers have been trained on a lot of these elements. And when you find older training, it's not necessarily the up-to-date guidance, but that helps give you at least a view on how these are normally framed and what cases are often used in framing them for the asylum officers. And that can kind of help you think about how you want to frame them. But yeah, not a huge focus on case law, but big focus on making all of the arguments on each element extremely clear and tying them concretely to the evidence that you're presenting. Make sure you make all available arguments, if there are alternative claims relief, possible, different phrasings for protected grounds, humanitarian asylum claim, past and future persecution. Do not leave any of that on the table. And we are here to consult if you have questions about how to frame any of this and make these arguments. To keep that in mind. And I think, Lisa, it goes back to you here.
That's right. Hey, everybody. There's my camera. So this is just an example of case timing. Again, knowing that it's very possible that some of these cases could be scheduled for interview in very short order. This was one example that we offered of, and this was in to the firm representatives. This was when we described this project. This was our suggested timeline for cases. But let's go to the next slide and spend our last few minutes together talking about what actually will happen at the asylum interview, if and when it is scheduled. Know that the applicant must provide an interpreter. During COVID, the asylum office changed this practice, but they've reverted back to us bringing the interpreter with us. So that is your responsibility to find someone to bring along to do the interpreter. You want the interpreter to be a good, strong interpreter, not a family member, not a child. If it is someone from your office, that's okay. It doesn't need to be a professional interpreter, but it does need to be someone who's competent and proficient. And I would recommend that if possible, that be the person with whom you do asylum interview preparation so that your client and the interpreter are used to each other. The asylum office interviews, they might be as short as 2 hours. They might be as long as 6 hours. I was there. We shut the place down in December. We got there in the morning and our interview went all day long because the officer just had a lot of questions and it just took that long. So I think, plan that it could be an all day affair. And the officer, they'll have sort of a process that they go through. They'll review the entire I-589. They'll first swear in your client, and then they'll ask their substantive questions. And at the end, they'll ask their mandatory bars questions. And I think it's really useful to put your client on notice that at the end, just as an immigration court, when they ask questions about possible criminal activity or terrorist activity, or have you ever hijacked a plane, those are standard questions that they ask everybody. And it's not because the asylum officer thinks that your client in particular has done something wrong. At the end, there's usually an opportunity for the attorney to give a brief closing statement. Again, our role in the asylum office interview is much more limited in court. And for attorneys, it's sometimes hard. We kind of have to sit on our hands a little bit because we're sitting usually behind our client, staring at the back of their head, sort of like trying to help them respond in the way that they're hoping that they do. But really your role throughout the interview is, sometimes it may make sense for you to intervene. We want to do that very cautiously and in the limited capacity. The asylum officer, it's a non-adversarial conversation between the asylum officer and our clients. And so we don't want to interject much, but if something is going off the rails, if something is inappropriate, if there's just like a significant miscommunication happening, then you can gently intervene. And I usually say something like, officer, if I may offer, I think that if you look at tab K in our filing, that will clarify the line of questioning that you're raising or something like that. There have been times where I've been aware that there's like an interpretation issue and I've raised that. There is an interpreter monitor. So even though we bring an interpreter, the asylum officer for most languages will use their speakerphone to have a person who also speaks that language monitoring our interpreter. So that's something to prepare your clients for, that there's going to be someone on the other end of a phone line listening to their case, but that person is also sworn to confidentiality and should only interrupt if there is some mistake made in the interpretation. Your brief closing at the end, you can write a closing statement before you go into that interview and have something sort of prepared. I'm usually reacting to what happened in the interview. I'm usually looking at, okay, where did the asylum officer seem confused? Where did the asylum officer seem to not agree with the way we had framed the case? And those are the things that I'll focus on in the closing. Like really, you're trying to give the officer the roadmap to grant asylum and be responsive to whatever it is it seems like they still have questions about. Keep in mind, sometimes the asylum officer at the very end, they're like closing down their computer and packing up and they're not listening to your closing. You don't need to belabor it. But it's also an opportunity in some instances, if something significant was missed in the interview, then you might ask the officer for the opportunity for you to ask your client a couple of questions, or you might say, officer, I believe, paragraphs 9 to 12 of my client's affidavits maybe didn't come through in the interview. Would it be useful for us to review those together or something like that? Like you're definitely being very deferential. You're trying to keep the waters calm and help the officer find their way to approving your client's case. But that's sort of the role of the the role of the attorney at the asylum interview. And we can pop to the next slide, which is how do you prepare with your client for these interviews? It's not like court where you get to, run through a direct and familiarize them with the precise questions that they'll be facing in court. But that is actually how, when I'm preparing for an asylum interview, I do essentially write up a direct exam because that's going to help the client understand what are the pertinent facts, what is the salient information that I want them to focus on and be ready to share. And so we'll usually do one prep session where we do a very directed, like I'm asking a ton of questions. Some asylum officers ask very open-ended questions. So I'll usually do a second preparation session where I'm asking much more open-ended questions and seeing if they can get to the information that I'm hoping they will share. I think for children, it's just really important to stress to them that you're not asking them to memorize a script. their only job at the asylum office is to go in and tell the truth. And you're there to help them tell the truth. And you're there to help them. If they forget something important, you're there to help them, remind the asylum officer of that thing. We don't want them to be so stressed out thinking that there's a precise magic, word or language that they need to share, but rather their job is to go and tell the truth. And your job is to make sure that the asylum officer understands the reasons why they need protection in the United States. My one exception to that is I have them memorize one question, which is, why are you seeking asylum? Some asylum officers will open with that question. And you'll have this beautifully prepared asylum case. And sometimes clients will say, I'm seeking asylum because there's delinquency in my country. Or they'll say something, if they haven't thought about that, they'll say something that kind of undermines or suggests generalized violence, or suggests, something that is not particularly useful to your case. So I do work with clients and have them have one answer kind of pre-prepared. And then at the end of the interview, some officers will say, is there anything else you want to share? And you should tell your client that at that point, they don't need to come up with, I think, children especially sometimes will feel like, oh, I have to come up with something else to say. And then they might say something that is unexpected, or that you haven't talked about before, or that is not helpful to the case. And so I always tell my clients, if the officer asks you at the end if there's anything else you'd like to share, that is their moment to say, thank you for listening to my story. I have nothing else. And if there's anything else that needs to be shared, I will share it as their attorney in my closing statement. So I think those are the guidelines for preparing for an asylum interview. We've reached the 11 o'clock hour. And so if people need to drop off, that's fine. We're going to go through, we have just a few more slides that we'll go through, and then we'll hang around and answer questions if people have them. And this is also recorded, and we'll be sharing out the slides. So if there's more, if you want to circle back to this, we totally understand if people need to go, and we appreciate your time. Jeff, as people are dropping off, is there anything else they need to do for CLE? Or you've given them the secret word?
Yeah, so if you need to drop off, we will circulate the link for the survey after this. So if you can't get the QR code right now, we can circulate that.
Okay, a few more additional things to keep in mind as you're preparing your client for the interview. Discuss what your client is going to wear. I know this feels like we're micromanaging our clients and we don't want to, change their style, but really we want them to put forward the strongest presentation possible. So this is not an event to which you should wear like a hoodie, or in Central America for a long time the favored shoe of Mara Salvatrucha was the Nike Cortez tennis shoe. And so I always tell my clients, like, let's leave the Nike Cortez at home if that's the shoe that you have. Like, let's not give the asylum officer any reason to suspect that our client is anything other than the asylum seeking child who should be granted protection that they are. So you can be a little micromanagey. We have a former colleague who used to advise about haircuts and shaving that might go a little beyond what most of us feel comfortable doing, but do have that conversation. Discuss what your client will bring to the interview. They may or may not wish to bring their cell phone. It is possible the asylum officer will ask to review their cell phone. I don't think we want to get into like a huge conflict about whether or not our client is going to unlock their phone and make their social media accounts available to the asylum officer. So I would recommend they leave their cell phone back at your office and it's not there in most instances. And as we learn more about asylum office practices on that front, we'll share out. If, for example, they're going to say, well, then we're just going to continue your interview until you bring us this, then the calculation may be different. But I think for now, probably not bringing a cell phone and not bringing anything, other things that could be problematic to the interview is wise. Make sure your clients eat well, sleep well, confirm the meeting time. These are children. They have a hard time showing up on time. It takes them a long time to walk 2 or 3 city blocks. So if you're going to be walking from your office to the asylum office, give yourself plenty of time, prepare for a long interview, prepare for questions. This was a little bit new and different. With children, we see the asylum office ask pretty extensive questions about children's lives in the United States. And it may be that they're screening for human trafficking. They want to make sure that they're not paying someone for their food, that they have a place to sleep. But at my last interview with an unaccompanied minor just a few months ago, they asked a lot of questions about who are your friends? Who do you spend time with? What do you do in the United States? Who do you see at school? Who do you see at work? And that was a little bit unexpected for me. So as you're preparing your clients, I would hit on those things. And then, like we said before, prepare for the terrorism and criminal clients at the end. And then also, as we mentioned before, prepare for client questions about how the case was prepared. So they may ask your client, how did this affidavit come to be drafted? You don't speak English and this affidavit is in English. How was this affidavit created? And there, I think the asylum officer is looking for, is there fraud? Does the client actually, were they involved in the preparation of those documents? So you want to make sure that they're very familiar with everything that you're filing on their behalf. And I think with that, that was the end of we can go to the next slide, our guidance on preparing and presenting the interview. If you don't have a case yet and would like one, you can email Charlotte and she can connect you with potential cases for your consideration. And if you've already accepted a case, then you will receive a letter detailing who your NIJC point of contact will be and how to proceed with your case. And if we hop to the next slide, two of our colleagues, Bethany and Rachel, will be holding weekly office hours where anybody handling cases through this project, so these unaccompanied children's asylum cases, if you just have a question that you want to raise, that you want to bring to them, you can hop onto those office hours. They'll be circulating. Again, when you get your letter from us with the case placement, we'll provide more information about how you hop on that Teams meeting and raise any questions that you have about your case on a weekly basis. And again, you're going to have an NIJC point of contact. And we are hoping that a lot of firms that have internal expertise on asylum cases will be able to provide a lot of or some of the support and expertise. But to the extent you need us, we are here. Thank you so much for joining us today. Thank you for considering representing immigrant children, and we look forward to working with you moving forward.